All right, we've taken a look at what makes the Supreme Court independent. Now let's focus on some processes. So we're going to start first here with the selection of Supreme Court cases. So here in the background, you see this is what's called at conference. So this is a little meeting room where the judges, only the 9 judges, no one else goes and meets, and they discuss the kind of cases that they want to hear before the court. All right, so we're going to talk about how a case gets to the Supreme Court. And I want to start with the picture down there. We have a little illustration of a case being argued before the Supreme Court. This is all we have because they do not allow cameras in the Supreme Court. So audio recordings get released, but video and photos cannot be taken in the Supreme Court. So the best we have are courtroom sketches here. But let's start with the case. So a case, like we talked about a couple days ago, a case is going to start in a court of original jurisdiction. That means it's probably going to start in one of the federal district courts, or more likely it's going to start in a regular old state court. Once the case has been decided, if the person who lost the case feels they've got a good argument and that the court didn't make the right decision, then that case can be appealed to the circuit court. The circuit court is going to hear the case again and, probably read the briefs, and they're going to make their ruling. And then after the circuit court has made a decision, the Supreme Court justices are going to review all of the appeals made at the circuit court level. So if your case was decided at the circuit court level and you still got a problem with the way the decision went, you can appeal to the Supreme Court and the judges will think about it. If the justices decide to hear the case, they're going to issue what's called a writ of certiorari, and they're going to send that case up to the Supreme Court for review. All right, so how this is going to get started at the Supreme Court level is we're going to have the litigants. Remember, the plaintiff and the defendant. The litigants are going to file a petition for cert, which means that they are asking the court to issue that writ of certiorari. So they're going to file an outline of the facts of the case and the history of the decisions in the case. It's up to them to explain to the justices on the Supreme Court. They have to explain why the Supreme Court should want to hear this case. And they want to explain why they need to explain why the circuit court got it wrong. But they need to be explaining to the Supreme Court why it's important that the Supreme Court make a decision once and for all on this issue. It's not just the litigants that are going to get involved here, but we'll also maybe see amicus curiae briefs. So amicus curiae briefs are going to be filed that will encourage the Supreme Court to grant the writ of certiorari. Now, in reality, a lot of this is handled by the staff. So these people, we call them clerks. They clerk for the justices. So they read all this stuff. If they find something that they think particularly interesting, they give it to the justice. And each justice, we talked about the circuit courts, each justice is responsible for a circuit court. And so each justice is going to get all of the petitions from that circuit that they are in charge of. All right, so the next step is what we call at conference. So that was the table at the beginning of this section here. Only the 9 justices go to this meeting, and they have assigned seats. They sit by seniority, who's been on the court the longest. So you really, you might end up sitting next to or sitting across from the same person at work for decades. But they're going to sit at the meeting according to seniority. The Chief Justice has what's called a discuss list of cases that the Chief Justice wants to talk about. And then any justice can add a case from their circuit to the list. So they're going to discuss all of the cases that are on the list, say, hey, here's why I think this is important, and they'll decide if any of the cases are worthy of getting a writ of certiorari. Now, to make this decision, this is an important rule. This pops up on the test all the time, but the Supreme Court, when they are deciding if they want to hear the case or not, they have a little vote, and they apply what's called the rule of 4. Remember, there are 9 people on the court, but if 4 of them agree to hear the case, then the justices will issue the writ of certiorari. So the rule of 4 is very important here. They vote out in the open, they talk to each other, they try to convince each other to vote a certain way. But the rule of 4 is important because there's 9 on the court, right? 9 is not a majority. So this is how the Supreme Court kind of symbolically protects the role of the minority, right? They're protecting those things that are not overwhelmingly popular. And so even if a majority of the justices doesn't agree that this case is worthy of making it to the court, if they can get 4 of them to say yes, then they will issue that writ of certiorari. All right, and then the writ of certiorari itself, this is a formal order for the lower level court to send that case up for review. So what that means is they're sending all of the briefs. Any brief that had anything to do with it goes up to the Supreme Court, because what's going to happen before the case even gets to the Supreme Court, the justices read all of the briefs. The justices read every little fact in detail, because they're not going to be presenting this stuff in court again. So the writ of certiorari basically just tells the lower court, send up all the information. We got to start studying before this case gets heard. Now, it's not important, but little sad thing down there. You've done all this work, right? You've spent hundreds of thousands of dollars getting your case before the circuit courts and begging for the Supreme Court to hear it. If the Supreme Court rejects your appeal, you get a 1-sentence letter from the court. You don't get an explanation or anything. It's just like, we're not interested in hearing your case. So you have wasted thousands and hundreds of thousands of dollars. All right, finally, we've made it to the moment in the picture. We're actually going to have a case before the Supreme Court, and there is an actual court case that happens here. This is what we call oral arguments. Now, here's the weird thing about the Supreme Court. The case before the Supreme Court, they're making the most important decisions, but the case is almost always just 1 hour long. Each case is usually going to get 1 hour, 30 minutes for each side. And the lawyer gets up there, and the lawyer is like, they've prepared a speech that they want to make. They're going to give all the legal arguments about why the judges should side with them and everything. But the judges have been studying all the briefs. The judges already know all the facts about the case. So the lawyer has a plan for what they want to say, but what actually happens for most of that 30 minutes is the justices are grilling the lawyer. They stop and interrupt the lawyer, and whenever they want, they just start asking questions about the arguments or about hypothetical things that might happen if they decide a certain way or not. So the justices really dominate all of this time. It's basically the lawyer for the plaintiff goes in there, and the Supreme Court justices ask him questions for half an hour, and then the lawyer for the defendant has to answer questions for half an hour, and you get your court decision months later. But this is oral arguments. This is when the case actually finally reaches the Supreme Court. All right, the other very important aspect, other than how the cases get to the Supreme Court, is which judges get to the Supreme Court. So let's talk about how the judges get selected to be on the Supreme Court. What we have here, you can see the Senate Judiciary Committee is reviewing, this is Justice Sonia Sotomayor. So they're vetting her before the vote on whether or not she would join the court. All right, so at all levels of the federal court, all federal judges are appointed by the president. There's a little less than 1,000 judges working at all of the different levels of court between the circuit courts, the district courts, and all that. So the president is appointing lots of judges at lots of different levels here. Each one has to be appointed by the president and approved by the Senate, because that's what the Constitution says. Now, for the Supreme Court, there's a lot of scrutiny here, because these are the 9 people that make the final decision on everything. We pay a lot less attention to appointments to district level court and to circuit courts. So the Supreme Court is the ones that we really like. This becomes the main story in the news for a couple of days while the hearings take place and while the vote's going on. Now, at those lower levels of court, at the district level and at the circuit level, there's a process that we call, this is an old custom that we call Senatorial Courtesy. It does not have to happen, but this is usually how things go. This is mostly to save time, and because we don't need to have a debate and spend days talking about every single judge that's going to be judging down at the low levels of federal court. So the president's making an appointment. He's going to give a courtesy to the senators from his party in that state. So senatorial courtesy means the president's going to check with the senator to see what they think. So the president tells the senator who they're thinking about, and the senator basically gets to approve or veto the president's suggestion. So the president say, hey, I've got an idea. Well, I think I'm going to nominate this person to the court in your state. And the senator could say, no, that's terrible. You can't do that. Or the senator would say, that's great. And then the whole Senate is going to vote that way. This is, in many cases, the senators can even recommend people on their own. Like, hey, they've got a president in their party. They might tell the president, hey, I really think your next opening, you should put this person on the federal court. They would make a great judge. Now, this is a tradition and a custom. It does not have to be followed. And so our presidents that are less likely to keep up with tradition and custom have been ignoring that. This was pretty rare under President Trump. This was becoming a little more rare under President Obama. So it may be a thing that's going away, but this is an old custom that they make sure and put on the AP exam all the time. Now, for the Supreme Court justices, the president is going to, obviously the president does not know thousands of justices, judges all around the country. So they're going to get recommendations from the Department of Justice, and they're going to, mostly the thing that they're going to focus on is appoint someone with a similar ideology. A judge with a similar ideology to the president is a way that the president can make sure that they have their legacy or their policy impact is in the government for years after they leave office. So they will mostly focus on the justice's ideology. So a liberal president is going to nominate liberal judges, and conservative presidents are going to nominate conservative judges. Now, it doesn't always work that way because, like we said, the judges serve for life. And a pattern that we see in the judges on the Supreme Court is over time, judges in the last few years or the last few decades here, the judges have gradually moved while they're on the court from being conservative to more liberal. So we can talk later about why that is, but that means that sometimes the judges that we consider to be the liberal judges, those judges have actually been appointed by Republican presidents a long time ago. So we'll talk about how the makeup of the court changes over time as well. All right, so what is the president looking for when they pick a Supreme Court justice? Like we said, the most important thing, ideology, right? Ideology is the single most important factor here. Make sure that you burn this into your brain, make it ideology and not party, right? The judges are liberal or conservative, so the judges will be picked based on the president's ideology. The other thing that the president wants to pay attention to is their age. If the president picks a younger judge, they're going to be able to stay on the court for a very long time. We recently lost Ruth Bader Ginsburg, and she was on the Supreme Court at age 88. Right? There have been at the beginning of Obama's term, the judge that retired was 91. So if you put a 50-year-old on the court, they may be judging for 35 years. And so that's a really important thing for the president to consider. Presidents will also consider things like demographics. They may consider gender or race. They may consider religion. They used to consider region a lot. I know your book talks a lot about geography. We don't really care about that anymore, but that used to be a really important thing for presidents to think about. Now they're more likely to think about different races on the court, different genders. They're trying to make the court more diverse to reflect the decision-making of the American people. And of course, the president will also pay attention to experience. A judge that has a long track record of being a judge is more likely to be confirmed. It's really rare now that someone makes it onto the Supreme Court without judging experience. Not to say that it never happens, but in the past, we've had presidents go right onto the Supreme Court with Taft. Might have lawyers or things like that who haven't been judges, but usually experience as a judge is really important. Now, political parties do come into play a little bit, but not with the judges. Here, the president has to think about the partisan makeup of Congress. So if the president and the Senate are controlled by the same party, then the president's going to be able to pick almost whoever they want. But if the president is dealing with the opposite party in charge, then that's going to mean that the president needs to pick someone who is a moderate as a compromise. So if the president is a Democrat and the Senate is controlled by Republicans, the president can't just pick the most liberal judge he knows because that person's not going to get approved. The president needs to pick somebody more moderate, more in the middle, and the Senate is likely to confirm. Now, the Senate usually confirms the president's choice anyway. There have only been 29 nominations rejected all time for all sorts of different reasons, like not enough experience, or they have really wild political views or something like that. But usually the president is going to get their choice. All right, and we'll reiterate this again. Judges do not have political parties, right? We don't say that judges are Republican or Democrat. They have ideologies. They are liberal or conservative. So the president needs to think about which party is in control of the Senate when they make their pick. So this is how the president is going to consider, which kind of judge he can get through the Senate. The president also needs to think about how their party is going to react to the pick. So the president is going to have to keep their party happy as well. And then almost the last step here, the last thing we do before the vote is the confirmation hearing. These get a lot of attention. These are on TV. We watched a little bit of some this year. It's, doesn't happen often, but it's a big deal when it happens. So the Senate Judiciary Committee is going to interview the judge. They're going to look at all sorts of things about the judge's history. They're going to look at the voting record of the judge, like how they've ruled on previous cases, so they can kind of predict how they'll rule in the future. They'll ask the judge questions about judicial philosophy, about their stance on controversial issues and things like that. And then, they'll also have to talk about if there's any kind of controversial issues in the judge's past. That's become a more regular occurrence in our Supreme Court nominations. So if the judges have a situation in the past that might mean that we don't think this person ought to be on the court, that's a thing that comes up a lot. So this process is what we call vetting. The Senate Judiciary Committee will vet the judge, and then they will make a recommendation to the entire Senate about whether we should vote to approve or deny the appointment. All right, that was a lot of process there. We looked at how a court case gets to the Supreme Court, and we looked at how justices get onto the Supreme Court. So a couple of complicated processes there that we need to think about. Now we're going to move on to a little more political stuff. We'll talk about the opinions and the political makeup of the court.